personal views and opinions expressed by our podcast guests are their own and are not legal advice or official statements by their organizations. Hello, my name is Debbie Reynolds. They call me the Data Diva. This is the Data Diva Talks Privacy podcast, where we discuss data privacy issues with industry leaders around the world with information that businesses need to know now. I have a special guest straight from the UK, United Kingdom, Ralph O'Brien. Ralph is the principal at Reinbo Consulting Limited in the UK. Thank you for being on the show.
It's absolutely my pleasure. Thank you for inviting me. It's an honor to be in front of the Data Diva herself.
Well, thank you. So your profile has always attracted me because I see you commenting a lot. I think I'm attracted by people who have their own views and they put out content and they comment a lot. You have a lot of deep experience in privacy. And I, in general, like to talk to people in Europe about privacy, where I think a lot of people in the US, especially before the GDPR came out, privacy wasn't like a huge thing unless you're dealing like finance or health or something like that. So I feel like people in Europe is so steeped in the culture of the EU about privacy. And so I love to have that kind of deeper, richer perspective. And then you're in the UK too, and this is post-Brexit and all that stuff. So I'm sure you have really interesting things to talk about. Give us a little background about you and your journey into privacy so that the audience can get to know you.
Well, I'm sure, like everybody sort of grows up wanting to be a privacy lawyer now. A bit of an odd journey, to be honest. My educational background was in law, but I actually ran away. It wasn't until I was at university studying law that I kind of went, what am I doing here? When I was younger, I actually wanted to be a policeman, believe it or not. So I kind of ran away a bit and joined the army and ended up in communication security in the army. And they sent me somewhere hot and sandy. So I ran away from that as well. And ended up, ironically, joining the UK public sector in the late 90s when the Data Protection Act 98 came in. So sort of the second generation of UK privacy, because we had an 84 Act before that based on Convention 108. So I came in 98. Somebody saw law and computing on my CV, law and communication security, and said, go away and learn about this Data Protection Act thing. And as a sort of an 18, 19, 20-year-old, I kind of shrugged and went, okay. But then I went away and I fell in love, and I've been in love ever since. It was a privilege to kind of begin in the UK public sector, looking at, the needs of the government, the needs of the many, as opposed to the needs of the few or the one. For you Star Trek fans out there, the needs of the many as opposed to the needs of the few or the one. But then really when I was in the UK, I actually ended up working for the police, doing a lot on transfer agreements and the way data moved around the public sector. And there was actually a set of murders, a gentleman, I use the term loosely, called Ian Huntley in the UK, who killed a couple of girls, young girls at a school. And it came down to the way he was vetted. So he'd moved around the UK, and because he'd moved, his kind of records hadn't moved with him. And what kind of really made my career was really looking at the way the UK handled criminal records, the way they looked at the rights of privacy in the individual compared to the rights of the employer to know about your background, your past. So we wrote a number of standards. We wrote a few audit manuals for the police and later for the ICO. And then that led me to sit on a number of international standards bodies that make standards like the 27000 series for information security and privacy. And then one day I was arrogant enough to think that I could go and tell other people how to do it. So I went from being an assessor, an auditor, a sort of a creator of standards in the privacy world, a creator of audit manuals, quite early in my career, to helping organizations get those badges or to assess themselves against those standards. And I honestly, I wake up every day passionate and so happy that I work in the industry I do, because my raison d'etre, if you like, is to make a difference, is to help. And so that's been my sort of guiding light throughout my career, is to help make a difference.
And you succeed at making a difference. I think you make a very big impact on me and other people on LinkedIn with, just sharing your knowledge, sharing information, sharing updates about what's happening, having standards, thinking about that. So it must be kind of interesting. So as a result of GDPR coming out, so much more attention and focus has come on to data protection. And so the space is getting a lot more crowded than it was before when you were sort of working in it. So what has been your, I guess, what's been the most surprising thing that's happened as, after GDPR came out, with just the industry as a whole, you think?
Well, it certainly popularized data protection and privacy. I mean, I often say that my 20 odd years in data protection has been sort of fighting the rear guard of a losing action, right? Technology's increased, the scale of what we're doing has increased. But when the GDPR arrived, there was certainly a lot more management focus, certainly a lot more popularity in the industry. The industry has grown massively, a lot more technology companies moving in. Now, sometimes it's not always a good thing. The industry is slightly more competitive than it used to be. I mean, I'm here to collaborate. I still think it's sort of, these privacy professionals trying to work together, to make the world a better place. But sometimes I think the industry's gotten a little bit more competitive. People are a little bit more guarded with their methodologies, perhaps. But the industry is still a lovely place to work, generally speaking, for the greater good. I mean, there's certainly been an explosion of privacy professionals, some who are brilliant, some who know enough to be dangerous, who don't have the history, who have come in from a slightly different background. Perhaps they used to be in sales or marketing or a different background. There's a lot more lawyers involved. The UK privacy profession back in the 90s was kind of record managers, people with their hands moving through the files. So looking at ground level things like retention periods and accuracy and sort of the way data is accessed and the way data is shared. But nowadays, there's a lot more focus on things like international transfer and contracts and the legal side of the profession. Whereas, myself, I've always come from a place of wanting to have my hands on the data, looking at data quality. And what I really love about the industry looking forwards is that there's now this focus on privacy by design, actually making sure that we build privacy into new products and services. So GDPR, massive, massive change. And now we're going through another revolution again. I actually think personally that we're now at the stage where businesses are bigger than countries. Company is bigger than country, and therefore the regulators are struggling to maintain a control. You've got these big global companies, these big global technologies, but these little national laws. So, you've got this kind of, massive global conglomerates which are more powerful perhaps than the ability of a country's regulator to, call them into check. So then we begin down the data ethics journey, and the data protection by design journey, which again is another fascinating sort of step in evolution.
I agree with that. So so you pointed out some really interesting things about the industry, and I like to talk with people just sort of in all sort of backgrounds that come to privacy, which is really cool. And then, so I think one big misnomer, and maybe this is because of some of the organizations that have really come into prevalence as a result of privacy, this idea that that privacy is more of a legal thing that lawyers handle. That's not a true statement. And I think it takes people from all different areas to really make a difference in privacy.
Yeah, it is and it isn't. I mean, we've all got a role to play, from the from the regulators' side, from the lawyers' side. I'm not saying lawyers don't have a role to play. I mean, lawyers are brilliant when it comes to contracts and legal advice, but sometimes different people have come from it from a much more practical perspective. Actually handling the data. There's the technical IT perspective. There's the policy perspective. There's the sort of the software engineering perspective. All of this different perspectives, audit, even international politics now. I speak to you from a country that has actually left the EU now. Not my fault, I promise. I was on the other side. I always have to say this. I was a Remainer,
Yeah.
or a Ramona, as we're now called. But as a company that's left the EU and a UK at the moment that is now sitting between, let's say, America and Europe. Share a common language and culture with America, but at the same time, we kind of have this shared history and values with Europe, and a government at the moment that is trying to, make the UK a very business-friendly place to live and try and distance itself from Europe, thinking about deregulating or removing red tape. So, how close the UK remains to Europe, and how those sort of policymakers and governmental decision makers come into data protection here is going to be a fascinating journey to watch.
Yeah, I agree. What is for you right now top of mind in privacy? So what is the thing that concerns you most that you're thinking about right now?
Well, I mean, the thing that concerns me, I guess will be the thing that concerns my customers most. I've got customers coming to me talking about PIPL in China, obviously, as a recent development. There's still a lot of conversations around international transfer. The UK, I'm really concerned about this consultation the government has released called Data a New Direction, that in my humble opinion, it's dressed up in words that basically say, oh, we want to, get rid of the red tape and the administrative burden that organizations have in order to make the UK a more business-friendly place. But actually, what it looks like to me is they're almost removing some of the more administrative sides of the GDPR, and bringing it back to the principles. It's almost going back to almost like a 1984 Data Protection Act, as opposed to what the GDPR we have now, almost backing us up and removing some of those human rights, removing some of those more protections that the GDPR brought in. So I think it's going to be really interesting to see where the UK goes, because it's been granted an adequacy agreement from the EU. And if it then begins to grant its own adequacy to countries that the EU haven't, or it begins to deregulate data protection here in the UK, it's then we then lose those sort of adequacy arrangements with the EU. So, I think we stand on a really interesting balancing act, as always, between business and the individual, between the EU and America, between the devil and the deep blue sea, perhaps, right? So to me, data protection has always been a balancing act about the needs of the many, the needs of the one, the needs of the government, the needs of the citizens, and then contrast that with this scale that technology brings you out these days. And I don't think we've ever been in a more interesting and fascinating place. So I think data protection is more relevant now than ever, more important now than ever. Yet we're at this crossroads where you've got these global technologies and these little national laws, and the one can't quite keep up with the other. So I mean, it's just never been more fascinating, never been more passionate to be in data protection.
Yeah, I like the way that you describe that. Yeah, so I was wondering about this, and I'm glad you touched upon it. So the UK is kind of in the middle, in a way. So I feel like maybe the EU and the US are probably maybe pretty far apart on how
I'd agree,
we
yeah.
approach data privacy and data protection in some ways. And then the EU you guys are in the middle. So you have, because you're part of the EU, a lot of your laws sort of are parallel to that in terms of data protection. But then, as you said, as a result of Brexit and wanting to do kind of these different deals, the UK can give their own adequacy. And so that was my concern that I had. I'm like, okay, so if the EU, I was praying that the UK got adequacy from the EU, and I'm happy that that happened. If that directly impacts me and my clients who are in the EU and in Europe. But then if the UK gave the US adequacy, I can imagine that would raise some alarms in Brussels about, that relationship, because we in the US have not changed.
Yeah.
So it's like, okay, so what would be the basis for that? And maybe it will be something where it was more narrowly focused. I don't know. This is my thought. So I would love for you to jump in on this. So the a lot of the sticking points between the US and Europe about kind of how we handle data protection has a lot to do kind of with indiscriminate data collection and surveillance and stuff like that. So the GDPR doesn't really deal with the kind of the law enforcement part or the surveillance part. And then the US, we have laws that are saying, okay, in national, if it's national security or whatever, we do all these other things that you all don't do. So in my mind, I feel like we should separate the way data is handled or where we treat it in kind of law enforcement actions from how businesses handle it. So I can't stop the FBI from busting into a company's, office and take anything. So no matter how many contracts I write or how many standard contract clauses or whatever, I just can't stop that. Like there's nothing that a business can do about that. So I feel like that's the issue that we have right now. And I feel like instead of trying to say, instead of saying, okay, I'm in the US and I'm going to tell someone in the EU to give me this data because we need it for law enforcement. I feel like the government should be working that out, and then they work with the company as opposed to putting the onus on the company and saying, okay, well, you have to be responsible if the FBI busts into your organization and takes data.
Yeah, I don't disagree, actually. I think the problem is somewhat of a political one. I think that, actually, the UK was granted two adequacy agreements because we were granted the GDPR one and the law enforcement directive, a separate law. There's a law enforcement directive and the GDPR. Actually, anything law enforcement isn't covered by the GDPR. It's actually covered by the law enforcement directive. So a completely separate law. And then again, EU is not allowed to touch national security either. So actually anything law enforcement or national security are kind of exemptions from the GDPR. Where I think Europe and America differs, Europe obviously has got the fundamental rights approach, so human rights. America more of a consumer rights approach, more of a opt-out versus an opt-in approach, perhaps, yeah. And I think, there are lasting wounds in America that have come from September the 11th, 2001. That include things like the Patriot Act and the Pfizer Accords and the presidential executive orders. The way they differ from the way we do things over here, perhaps, is they're a little bit more secretive. You can gag an organization to kind of go, well, we're going to come and take your data, but you're not allowed to tell anybody about it. So there's a little bit less transparency, I think. Now, I'm not suggesting that the UK or Germany or France doesn't do national security, that they're that the Secret Service, MI5, MI6, CESG here in the UK doesn't collect data, right? Of course they collect data. But I think what difference is perhaps the scale, rather than doing indiscriminate mass collection, it's more targeted. There's more of a justification. There's perhaps more checks and balances and safeguards. Okay. And so those checks and balances and safeguards to the European courts matter, right? They matter. Now, you could argue, yes, your data could get intercepted where you go, but there's more safeguards, more balances, more of the ability of an individual to seek redress, more of an ability of an individual to be able to stick their hand up, be aware that this is happening, and be able to fight it or whatever. Whereas in the US, perhaps there's a bit more predilection towards national security, be able to do what they like when they like, and that's a paraphrasing, of course. There are controls, but not the same. So for me, what it comes down to is a political problem. And as you say, the problem at the moment is they say, look, if you're going to transfer data to say the US or anywhere else with a mass surveillance regime, well, it doesn't say no. It just says you need to make sure that you have a transfer mechanism, such as standard contract clauses or something similar, BCRs, who knows. But then it says, but they're not enough. As you've just said, Debbie, it's not enough to write in a contract. You can't do that because American law will still apply. They'll still be able to collect it. So then it starts talking about adding in these supplementary measures. These are sort of a new thing post the Schrems II decision. And they kind of talk about supplementary measures to making it okay, being things like encryption when you send it to the US, but holding the keys over here in Europe so that the US organizations can't compel you to give them to them, and then not encrypting it, not decrypting it when it's in the US. Well, doesn't that defeat the purpose of transfer, right? If it's not ever decrypted while it's over here, what was the point in sending it over to the US? So, really there aren't any good options. And to put it down on an average organization's, an average company's whim to say, you have to understand the law of the country you're sending it to, you have to put in additional measures that will defeat the national security. It's kind of nonsensical. There's no good option. The answer can only be a political one, but I can't see it being resolved anytime soon. The US has been pretty stringent on its national security over liberty. The EU is very much stringent on its liberty over national security. And, whilst the two are doing this, while the two are bashing heads like that, they might well come up with another agreement, a safe harbor, a privacy shield version 3, but you'd instantly know that would be followed by a Schrems 3.
Oh yeah.
some sort of challenge. So, I don't see this a problem going away. I wish my crystal ball wasn't working. I wish I could suggest a solution. But unless America suddenly turns around and passes the GDPR, or equivalent to the GDPR tomorrow, which I don't see happening, removes, adds in some additional safeguards in the national security. I don't see that happening, nor do I see the EU backing down and saying, well, the American approach is okay. Yeah. So where does that leave the UK? We're sat in the middle, right? Yeah. We're sat in the middle. We want to work with partners. The UK wants to change its brand to this sort of new, exciting, cool sovereign nation who can deregulate away from the horrible EU rules. That's not me saying that, by the way, or who can grant trade deals and adequacy agreements to all of these cool things. I mean, on the DCMS, the Department for Digital Culture, Media and Sport, on their agenda is granting adequacy agreements to Australia, Singapore, Taiwan, Dubai, the US, all of those nations not on the EU adequate list. It was actually asked at IAPP Brussels last week to the DCMS. Well, what happens? What happens when you grant adequacy to countries that the EU hasn't? And the arrogance of the answer will go with me to my grave. Bearing in mind they're sitting in front of an EU audience, the head of data transfers at the DCMS said, well, it could be we've done their homework for them. It could be that, it could be that we have looked at something, and if we say they're okay, why shouldn't the EU say they're okay? And there was a level of arrogance there that I found unrealistic, let's say, unrealistic. I mean, just to kind of clarify that, I know I'm taking long with my answer, but to clarify that, I mean, when the adequacy agreement first came through, you only had to look at the 2 press releases. The press release from the EU said, look, we've granted you adequacy, but be in mind, it's a limited thing. We've got to review it every 4 years. If you change what you do, that adequacy is going to go. It was very sort of coached in, you barely got this.
Right.
We could take it away anytime we wanted to.
Right.
And the UK's press release was, it kind of said, we were rightfully granted adequacy because of our brilliant privacy laws. Now we can go away and change them. We can unlock the power of data across the UK. it was the two press releases looked at side by side. It was kind of a strange day.
Yes, yes. I don't know, this is so complicated.
It is. There's no right or wrong answer.
Yeah,
Yeah,
it's very complicated.
it's just going to evolve, and this is what makes it such a fascinating space to work in. I mean, advising clients. For the first time, I actually found myself advising clients to not break the law exactly, but I was saying to clients, well, you're not going to stop transferring data to the US. There's kind of no good option to do it. So you're just going to have to do your best, which is put in standard contract clauses, try and work out what these supplementary measures mean to you, and sort of add them in. But if the business necessitates that transfer, you might just have to live with the risk.
Yeah, right. And a lot of it is, and I'm glad you mentioned that about advising companies. So for me, it's very important to educate them. Like, okay, here is the deal. Like this, here are the cards that you've been dealt. Okay. And then you have to decide for yourself how you want to play this. It's not me saying, don't do this, don't do that. I'm like, look, this is the deal. This is how things are. Here are your options. And you have to,
Sure.
whatever you decide to do, we can go that route or whatever. So I think that's all that you can do, because supplementary measures may mean different things to different organizations. So if you're Google, supplementary measures may be, very extravagant. You never know, but a little mom and pop shop down the street, their supplementary measures may be more simple. So I think, understanding, what is at play here, what the risks are, and then what also kind of reasonable, what is reasonable, what would someone consider reasonable for your organization?
I mean, data protection law is full of those sort of words. I mean, the one thing I actually do like about US law, I mean, I know US law gets a lot of criticism, but I know there's only sort of 3 states, Virginia, Colorado, California, with actually sort of data protection laws as such, limited though they are. What I do like is the sectoral approach. I do like the fact that you've got HIPAA and FERPA and COPPA, these sort of laws that can be a bit more specific about their specific industry sector. The problem we've got over here is these sort of big omnibus laws like the GDPR, a law that's got to cover all organizations in all industries, in all sizes. Is we can't be specific in those laws. It's got words like adequate and necessary and appropriate and relevant and proportionate, all of these wonderful legal words that, they don't say they don't say make sure your door's made out of metal or make sure it's encrypted, right? They say make sure your security is appropriate. They don't say this is the retention time. They say keep it no longer than necessary. And what that means is it's all risk management decisions, because even if you as an organization, you've taken good risk management decisions, the data subject, the individual, might disagree on what's necessary. The regulator might disagree on what's necessary for the purpose. That's kind of why I love it in a way. That's why it's so interesting, is because it's all an argument. It's all proportionate. It's all a risk management decision. It's up to the organization to decide how much it wants to follow the law, how far it wants to go down this road. And what I think is interesting is the motivational side I'm seeing changing. It used to be, people used to come to me and say, hey, how do I avoid a fine? What's the minimum I've got to do to hit the legal red line? What have I got to do to comply with the law? And now I'm seeing the motivation totally change. It's how do I use this to make the best product? How do I use this to achieve competitive advantage? How do I be better than my competitors, gain a good reputation in the industry? How do I do my best? And I think that's a much better position to be in, personally.
I like the way that you said that. I agree. So one thing that I'm seeing, which is a good change, is, as you say, I'm not seeing people say, okay, I want to avoid a fine, so tell me what I have to do like the minimum, even though we know companies do that,
Sure.
And so it's good that companies say, okay, I want to make a better product. But what I'm seeing that's really getting the attention of organizations is that if they want to expand and they want to do business in different locations, they literally cannot sell their product if they can't answer
Yeah,
those
yeah,
questions. So it is like, okay, you have the
yeah,
best product in the
it's true.
world. You have these investors and they're ready to sign on the dotted line. And they're like, well, so what's your plan? Do you have a policy? Do you have a procedure? Do you have people in place to sort of handle data protection? So I think it's interesting to see that people put so much focus on, they're like, okay, well, let's make this product and it's so awesome. And then, have data privacy be something that they think about last when literally they can't reach the finish line unless they deal with that issue.
Yeah, I totally agree, and I see that as companies expand globally. I mean, a lot of my customer base, even though I'm based here in the UK, a lot of my customer base is US based. They're companies who are using me because they're expanding into Europe or they've acquired a business here in Europe, and therefore they're having to deal with these new regulations for the first time, or even the UK company that's going into China and needs to deal with a PIPL. And so you've got this idea of internationality, this idea of global data transfer, but this idea of national law. And so how do we do that? It's very tempting to kind of say, well, I want to take advantage of the laws in different countries. You could equally go, well, I don't want to give GDPR rights to everybody, or I don't want to give, or I want to take advantage of a company of a country which doesn't have a privacy law, and therefore I can do what I like, right? But when you do that, you create differing standards across your business, and that makes sort of it harder to be interoperable, for want of a better word. A lot of the companies I deal with have now taken the opinion to go, I don't actually care what goes on in the UK. If the UK reduces its standards, we don't care because we're taking this sort of global gold standard, right? Therefore, it doesn't matter if your country gives people rights of access or erasure or portability. We're going to give them that, not because the law says it, but because that's our company's policy, right? And I think that's really powerful when a country says, we want regardless what the country says, a company says, we want to get to the highest global gold standard. So it doesn't matter where we operate, these are our standards. Right. And ethically, I think that will be a much more positive place to be. If the UK does derogate away from EU law and does its own thing, well, what are you going to do? Are you going to operate a dual standard, one standard for the UK, one standard for the EU? Or are you just going to adopt the higher standard and let the data flow? I'd do the second personally,
Yeah, great commentary. Let's jump a few thousand miles away from the US and the UK, and let's talk about China.
Okay.
Talk about the PIPL. So the PIPL, I think it went into effect November 1st of this year, if I'm not mistaken. And it's personal information protection law in China. So I think it's interesting. So have been familiar for many years about data protection and the way they handle things in China. I think some people were shocked that China actually did this law. And so for me, it really is them putting their stake in the ground and writing out for people who did not know before what their expectations were for businesses that handle consumer data of consumers in China. It to me is not that different. It actually, if you look over the years, over the way China has handled sort of data and businesses, you'll see in the law that that's what they were doing. So maybe people didn't understand it at a high level. They were kind of looking at it on a case-by-case basis, but I think it's good that they sort of put this in writing so that people understood this. So the thing that I was thinking, and I just want your thoughts. So people that I know that do business in China, they knew all this already. So I don't think this law told them anything new. They knew this, but people who want to do business in China that did not know how to navigate, they have a better clarity about what would be expected. What are your thoughts about that?
Yeah, I agree. I mean, again, it's certainly not a carbon copy of something like the GDPR, but it's definitely got a Chinese flavor to it. But there's a lot of commonality. You start looking at this, and I mean, nearly all data protection laws across the globe are based on the OECD privacy principles of 1980, right? Nearly all, purpose limitation, quality, security, individual participation, accountability. All of those old principles, data minimization, all of those old principles from the OECD 1980. What I actually love is they really haven't changed. In all of the laws across the globe, we see that commonality. Then you get, international transfers and rights and, data protection impact assessments. I mean, there's a huge sort of GDPR flavor being pushed into this Chinese law. So yeah, again, if you're an international company and you're doing most of these things already, the gap isn't going to be that big. Yes, there's a Chinese flavor to it. Yes, you are going to have to look at the detail, because there is nuance. But for most organizations that have done a sort of a GDPR privacy management program that moves you up towards that standard, that you're not going to have to do huge amounts of change to be to kind of be on the good side of the PIPL. I think it's still developing. There are a couple of bits in it where it refers to codes of practices where we haven't really seen them yet. It'll be interesting to see some enforcement, because they didn't give a huge window. They kind of just said, hey, the law's here. There wasn't like, oh, by the way, this is going to be enforced in 2 years' time. There wasn't a huge window there. So I think that's really interesting, that they kind of just kind of threw it out there, and a month later it was in law. But yeah, I don't see organizations that are already sort of up to the sort of the GDPR level, or having to make huge amount of details or differences for the way they do business in China. I mean, there is a little bit in there about data localization, which is interesting, keeping data local, which, if you're up in the cloud, might be interesting. But yeah, from the 1st of November 2021, we shall see.
Yeah. One trend that I'm seeing in kind of the Asia Pacific region in privacy regulation, not just with this, just over the years, I'm starting to see them create regulations where they're starting to go towards penalties, criminal penalties,
Yes.
as opposed to, civil penalties.
Yes.
And then also another trend I'm seeing in Asia Pacific is more data localization requirements.
Yes, definitely. So yeah, well, it's almost what I call counter globalization. So the more we globalize data, and the more these big internet companies, your Googles, your Facebooks, your Twitters, whoever, your Apples, your Microsofts, as soon as they sort of operate across the world, and we can I think truly as a human race, we should be thinking more worldwide now, but there's almost this counter movement. Brexit is a good example of it, actually. That there's this almost considered that the world is a threat somehow, and we need to lock down and take care and be a bit more xenophobic. And certainly with the government and the government security services, the idea that the data is somewhere else on the globe where they can't access it and can't see it is frightening. It's a barrier towards law enforcement. So yes, there's this big idea now of, well, yes, you can take the data, but you've got to keep a copy locally just in case we want to look at it, right? So which is kind of opposite to the way the world is going in terms of cloud and data migrations and single global approaches. So there's this real kind of dichotomy with the way the law goes. When it comes to criminal sanctions, I mean, it was always going to be the case in China. I mean, you mess up in Europe or in America, yes, you might well have a lawsuit against your organization. Yes, there might be financial penalties, but in China, you're appearing on national TV apologizing, literally prostrating yourself on your knees and asking for forgiveness. It's a very different culture in terms of that personal accountability of the management, right? The personal accountability of the management. Yeah, one of the things, in fact, I'm running a training course this week. I've got a 4-day training course this week in the British law. And, you know, even though we have got some personal liability, it's more for almost like criminal offences, like unauthorized access to computer systems, unauthorized modification, unauthorized taking data without the data controllers say so. So there are some personal liability offences. But when it comes to the regulator, when it comes to actions in court, they're always going to be against the organisation. So yeah, I think personal liability should well be pushed for, in my personal view, rather than corporate liability.
Yeah, I think too, another thing with these Asia Pacific regulations, the penalties they can be harsh and swift. So it's not something that's going to take years and years to go through a court process. Just like this law came out, it didn't come out of nowhere because they've been working on it for years. But if you think about how long it took the GDPR and the data directive and even the UK data protection, it takes many years for this stuff to develop. So in comparison, this law came out quite fast. It was developed quite swiftly. And in the past, even before the PIPL, if you look at the way that China treated companies that they felt ran afoul of something, like the penalty was like very swift.
Well, there are pros and cons to democracy. Democracy. I mean, democracy is fantastic, and I'm pleased to live in a democratic country, though obviously we've had to live with a vote that hasn't gone the way I've wanted it to recently. But yeah, the idea of democracy and the will of the people is it means you've got political parties who have to deal with the will of the people. It means that the political parties can't just set an agenda and do it. They've constantly got to be looking over their shoulder at what people think and what people feel, and you've got to consult and ask nicely and then water it down for people who don't like what you're doing. And whilst democracy is a fantastic thing, don't get me wrong, it does mean that it slows down the wheels whilst you have to consider the will of the people. I suppose the advantage, let's say, a Chinese state has got going for it is long-term planning. The government doesn't change. Therefore, that the people can't suddenly kick you out. So, that does mean that you can pass things swiftly. It does mean penalties can be harsher. It does mean that you don't have to worry so much about what people think and feel. You can just follow your agenda. Now, I'm not suggesting that's a good thing, but at the same time, it certainly means you can get swifter movement and harsher penalty. One of the things that bothers me actually is the ability of a regulator like the DPC in Ireland or the ICO in the UK to actually take effective enforcement action, because their budget is not the same as a Google or Facebook. Google and Facebook can appeal. They can put you to tribunal. They can throw good money that you don't have as a regulator. They've got more money than you at the end of the day. They've got more resource than you, a deeper bench of lawyers than you have. So, they will have the ability, a big global national company, to frustrate a country's regulators' efforts. And, I think it's only got to be by joining up, or by pooling our resource, or by even just appealing to their better nature, talking about data ethics rather than complying with the law, pointing out the competitive advantage to them, that even the largest companies will ever toe the line, so to speak.
Yeah, it's fascinating. I could talk about this for hours. Well, why don't we talk a little bit about the Lloyd Google case? We chatted a little bit about that before about the session, but just tell me first of all, just introduce us to what this case is and what it's about, and how the UK plays a major role in this and the impact.
Okay, yes. So Lloyd Google. Okay, so Lloyd Google was a court case decided in the UK. It was a gentleman called Mr. Lloyd, who was actually representing 3 million Apple iPhone users. Okay. And the case was both brought in the US and in the UK, actually, interesting enough. In the US, it was settled out of court. It was settled out of court under a consent decree. Under a consent decree, it was settled out of court. But in the UK, it actually went to court. Okay. Now, it really wasn't really about the facts. The facts of the case are pretty obvious. The Google had a workaround to get around sort of iPhone, Safari security in order to get personal data on people. There's nobody doubting the facts that Google put a workaround in place that got people's personal data in a way that Apple and Safari didn't want them to. It had a workaround, a hack, if you like. And therefore, Mr. Lloyd brought this case on 3 million iPhone users to kind of say, hey, we should be entitled to some sort of compensation for damage or distress. That's what it says in fact, it wasn't even done under the GDPR. It was actually under our previous law, our Data Protection Act 98. So that's the facts of the case. There's nobody denying that Google didn't do this. So you could argue, well, if Google is so guilty, why shouldn't people get compensation? Well, and it came down to the fact that the UK is actually quite resilient to what you in the US would call a class action. That they kind of don't like them here in the UK. We don't kind of have almost that more ambulance chasing lawyer culture here. And the courts traditionally have been very resistant to it. So what did they say? They said a couple of things. One, they said, could you really say that all of these 3 million people had suffered the same level of harm, which is needed in a representative action here in the UK? You need to be able to say that all the claimants have the same level of harm applied to them. Now, clearly, you could say the same thing occurred to them, but whether it was the same level of harm, you probably couldn't say that. You couldn't say that one person would have the same harm in terms of privacy from another, from Google exploiting their data in this way through the Safari browser. The impacts might be different on each individual. And secondly, they kind of said, well, are people really hurt? So you've got this concept of damage or distress. And what Lloyd argued was that the loss of control of the data was sort of damage in itself. Me not knowing where my data was, Google having my data and taking my data without my say-so, that was a damage, a harm to me. And the courts ruled otherwise in both respects. They said, well, you can't prove that everybody was damaged the same, so the class, if you like, doesn't really work. Not everyone has suffered the same damage. And secondly, they said, well, is loss of control damage? And they said, we don't think it is. We don't think that you can kind of prove that you've been damaged just because somebody else has got your data that you didn't want to. It's almost a case of then, if Lloyd had argued what Google then did with it harmed people, that would have been more likely to be awarded damages than just saying it's the loss of control. Someone else having your data you didn't want to, that's not a damage. It's just someone else having it, that doesn't physically cause you damage or distress. So it's made it a lot harder here in the UK to kind of A, do a class action, made it a lot harder, and B, kind of claim damage or distress, because the problem is with these representative actions, in my mind, if you're claiming, I don't know, against Google or Twitter or someone like that, the level of harm each individual has probably doesn't make it worth going to court. You could spend thousands on the court case, but the damages could only be less than 1,000, say. So how else do you take someone to court than through some sort of representative action where you've got a law firm acting on behalf of a greater number of people? It's the only way to make it economical to take that to court. So I do kind of agree with their decision, but I don't agree with the consequence of it, that Google gets off scot-free, that people don't get compensation, that it makes it harder for people to take action. I don't agree with the consequence, but I think in terms of the UK law, it was actually a sound decision. I can see their reasoning. Whether this holds up under the GDPR is another matter, because it was done under the previous law, the 98 Act, not the 2018 Act, the GDPR. Yeah, it's complex. It's complex again, but it certainly made class actions or representative actions a lot harder to do here in the UK.
Yeah. Yeah, this is a big case. I know a lot of big tech companies are breathing a sigh of relief about how this sort of came out because they're concerned about having, millions of people in class actions, and being and having to sort of pay some type of, redress there. So what we have in the US in some cases, well, first of all, we don't have kind of this strategy at a high level about data privacy like a GDPR in the US. But we do have, states, and like you said, we have sectoral laws, and those will result or have resulted in class action type lawsuits. And a lot of those are capped at a certain amount. And then also the thing about whether harm is tangible and intangible gets resolved. So like you said, in those class actions, for the most part, you have to show some type of harm. So the only law that I can think of right now that people are concerned about in the US that you don't have to show tangible harm is the Biometric Information Privacy Act in Illinois. So that one is, that one snuck past everyone when no one was caring about data privacy. That Illinois just snuck that law in, and it's, played a big role. And I know a lot of people are really looking at that very closely for that reason. So they don't have to show tangible harm. There is no cap really. The damages by data collection. So every time you collect someone's biometric data, it's, it adds up. But I think that another difference between the US and kind of the Europe in the way that we think about data, the way that the laws are written, it is based in the US very much on a consumer right as opposed as opposed to a human right. So for some people who think about it as a human right, that right, would be a cradle to grave right, and then there's some intangibility there, right? So I think that's what makes it more complicated. Where in the US, it's like, okay, I bought this thing, and we're going to calculate these fees and all this other type of stuff. So I think because it's harder to express the human part of the law, it makes it harder to do, I think.
It does. I mean, as I know, a lot of things have been done under Section 3 of the FTC Act, which is, unfair and deceptive business practices, right? So, it's less that you have breached someone's human rights and more that you have broken your promise to your customer, right? That's more, as I understand it, where the US law is kind of based.
That's right.
Yeah, exactly. But again, there's also this culture of settlement or consent decree. This settlement before it goes. Now we haven't really seen that in over here, and we did see it in the British Airways thing here in the UK. So British Airways had a data breach. It was fined by the regulator, a large amount of money. But then equally, there was a very similar sort of case brought against it, which British Airways settled out of court. I think it was about 750 per person, where they were going for almost 2,000 per person for the court case. So we have started to see that little bit of settlement. I mean, personally, I'd be more worried. So the GDPR, not a lot of people realise it. It's actually got two sort of separate streams of financial penalty. It's got the regulator fine, which could be 20 million euros, 4% of global annual turnover. Everybody knows that one. But that doesn't actually recompense the data subject. That just goes into the public purse. That's just a fine, a penalty from the regulator. But where it also has this compensation for damage or distress, that is the individuals who access to justice through the courts to gain, damages through the courts. Now, we haven't seen a lot of them. And I think that's a more interesting route, because where the regulators fail, where the regulators have been tied up for a long time, I actually think the class action route is more likely to achieve success. And 4% of global annual turnover, or 20 million, even though it sounds high, if you've got 20 million customers and you've damaged them for $1,000 each. That's a lot of money, right? So that the size of those class actions with a big tech company is certainly one that is much more scary than even a regulatory fine from a supervisory authority here in Europe. So I think those class actions would be more of an interesting thing to occur. So yes, Lloyd versus Google to me was, I don't think wrong in law, but disappointing in terms of the way I would personally like to see these large organizations held to account.
This is fascinating. We have to talk more about other cases that are coming up, because this you're in the middle. So you have a front row seat to all the wacky geopolitical things that are happening.
Well, I mean, one of the great things about being based here in the UK and with all our history and things like that is we do have, large global organizations that route their data through the UK. We might be a small country, but actually what's sort of fascinating about being here is we are the English language speaking part of Europe. So America likes us for that reason, but we're also still a part of Europe. So that Europe likes us for that reason. We've got a huge financial community here. Most large global organizations will probably have an outpost here in the UK at least. So, it does mean that you're being here in the privacy. It's a real privilege, actually, to be I've worked with some amazing organizations and some terrible organizations over the years. And it's just been a fascinating privilege to be on this journey and to kind of see where it takes us. I can only hope in the future the UK government don't sort of degrade individuals' human rights and privacy rights in an effort to be more business friendly, like the consultation paper suggests. But I mean, who knows? I don't have a crystal ball. We shall see what happens, and it'll be a privilege to find out.
True, that's true. So if it were the world according to Ralph, and we did everything that you said, what would be your wish for privacy anywhere in the world, whether it be human, tech, law, anything?
Wow, the world according to, hey. Well, don't do what I say. Bloody hell! I mean, I'm a servant, right? It's a privilege to help out organisations and to assist them and guide their risk. I don't have any desire to lead or to impose my will on anybody. So I'm not really sure. I should plead the fifth, as you said. Plead the fifth. That's correct, isn't it?
Yes.
Yeah. On that one, but I mean. It's respect for me, right? We live in a global world with global business. And I think what bothers me is, I mean, you only have to look at a privacy notice or a privacy policy in American parlance, which starts off with your privacy is very important to us. When you say your privacy is very important to us, that's the same as an Englishman saying, with all due respect. I mean, you know what's coming next, right? And it's not going to be nice. A privacy policy to me actually doesn't really describe how you're keeping the data private. It does the opposite. It actually describes how you're going to use it, how you're going to move it around, what you're going to do that impacts on their privacy or removes it. So actually, privacy policy is kind of a misnomer. So to start that with your privacy is very important to us, I would rather see more of a value transaction, more honesty. Organized saying, look, this is what you give and this is what you get, right? And then leave it up to consumers. So don't dress it up behind your privacy is very important to us. Just be honest. Actually say, look, this is what we want to do with your data. This is what you're going to give us. Here's the value transaction. Make an informed choice. Yeah. Yes, I'm a bit of a privacy advocate. I'm a bit of a human rights advocate. I do believe in people's privacy rights. In the UK, we're trying to pass this thing called the Online Harm Bill. The Online Harm Bill talks about making providers make sure you can't have anonymous accounts because you don't want trolls and bullies and people hiding behind anonymous accounts. But for every troll or bully, there's a child who is questioning whether they're straight or gay, who wants to browse the internet and find out about that culture without labeling themselves, without it sticking to them for the rest of their lives, right? There's someone who is potentially transgender, who is who is in an environment or a family where they can't be or are restricted from being who they want to be and fulfilling their potential. And therefore they have to go to the internet and they can't use their real name, right? So for me, everything is a balance. You know, for every move we take online to protect ourselves from a troll or a paedophile, we're also then impacting the rights of people who need to be anonymous for good reason. Yeah, there is no easy answer, but what there has to be is a balance, and this slow erosion of privacy and decency. Perhaps I'm just from a different age range where, you know, when I was brought up, I could browse the internet with a little bit more anonymously. I wasn't tracked and traced wherever I went. I could meet people who disgusted me or thrilled me in equal measure. And I think that's our right as a human to make mistakes, to not have things held against us and categorized against us forever for, you know, for the mistakes we made when we were kids, to not be categorized and followed and, you know, surveilled, but to able to be a bit freer, a bit more, to be able to, you know, live our lives in a way, not without consequence. I do believe in people taking responsibility for their actions, but in a way that is free from interference until you do something, you know, on the worst side. I mean, I don't have the answers. I don't have the answers.
That was a great answer though. I think, I mean, this is so open, you know, if it were easy, we wouldn't be here.
Yeah, but this is what I love about the industry. I mean, what we're fighting for is the soul of humanity, right? There's nothing worse, nothing greater than humans. We are terrible and brilliant in equal measure. And with all of that terribleness and brilliantness, you know, we have to legislate in a cyberspace of technology that is kind of almost beyond our understanding and logic and ability to explain. We're moving into AI and drones and robotics and stuff that, you know, I can use an app on my phone and a little trundling robot, delivers my shopping to my door. How beautiful is that? That was science fiction when I was a kid. But that comes with data and surveillance and you know, the people be able to track where I am, and you know, these things don't come without costs. So the very fact that you and I, Debbie, are able to have this conversation between transatlantically on a web conference system, and it be like we're in the same room. I mean, how beautiful is that? But how scary.
Yeah. Well, I really enjoyed this. I'm so glad we got a chance to talk and meet. This is fascinating. So I'll definitely be continuing to watch you and things that you do, you know, on LinkedIn, and, you know, keep up the good work. You know, we need all of us, you know, it takes all of us to be able to share information and get information across. And, you know, as you say, you do as I do. So I think, you know, businesses can do business. You can do business, you can make money, but you can also respect the rights of humans.
The two are not mutually exclusive. It is a win-win positive sum. It doesn't have to be a negative sum. I agree.
Well, thank you so much again, and we'll talk soon.
The honor is all mine. Thank you, Debbie.
Thank you.